So I'd like to call this regular meeting of the Lane County Board of Commissioners back to order for Tuesday, November 6, 2018 in our afternoon session. And our agenda is going to start with our public works items, as I'm trying to flip to my agenda so I get to read it incorrectly. And we are starting with a third reading and public and continued hearing on Ordinance 1808 in a matter of amending Lane Code 16090 definitions, 16210 F1 zone, 16211 F2 zone, 16212 EFU zone, and 16214 ML zone, and 16264 telecommunications tower standards to update definitions, modernize terminology, enhance the user experience by simplifying the code, streamline review processes, and align the code more closely with state law, and adopting a savings and severability clause, file number 509 PA 1805035. And this is a continued public hearing today from the September 11th, 2018 public hearing. The purpose of this hearing is to review the proposed Lane Code amendments, and they are subject to the applicable criteria identified in Lane Code 12005 at 12050 and 162522. The order of the proceedings for this hearing will be first the report by staff, followed by the public testimony, and then additional comments by staff. Failure to raise an issue with sufficient specificity. I never get that quite right. Specificity, yeah, that's a tongue twister. To enable a response may preclude appeal to the Land Use Board of Appeals on that issue. Prior to the conclusion of the public hearing, any participant may request that the record be left open to provide an opportunity to present additional written evidence or arguments regarding the application. However, we're not obligated to leave the record open, as this isn't a land use quasi-judicial procedure. The board's decision may be appealed to the Land Use Board of Appeals in accordance with ORS Chapter 197. And at this time, I'd like to call for any disclosure of or abstentions due to conflicts of interest or biases from the commissioners. Commissioner Sorensen?
I have none.
Commissioner Lykin?
None.
Commissioner Farr?
I have none.
Commissioner Williams?
None.
And I have none. And I'd also like to call for any challenges to the board's qualifications to hear this matter. Seeing and hearing none, then we'll move on to the staff report. Amber?
Thank you, Chair. Good afternoon, Commissioners. Again, this is a third reading and public hearing that was continued from September 11th on Ordinance 1808. Before summarizing the staff report, I would like to point out that the packet, the board's packet that was posted online was updated on Friday, November 2nd. That was updated to correct a typo in the EFU replacement dwelling provisions, and also to provide reference to the fact that the definition of party in Lane Code 16090 has been deleted with Ordinance 1802, the Chapter 14 amendments. And so the intent of this ordinance is not to add it back in, but to leave it deleted. At the September hearing, the board provided direction to staff to make a few changes. First, the board directed staff to revise each of the resource zones to prohibit sign illumination, and also to add back into use 4.3, that's the mining and processing use, the compatibility criterion that's currently in the F1 and F2 zones. Those changes have been made and are reflected in the draft that's before you today. We've also proposed a revision to the EFU replacement dwelling provisions, so that's a staff recommended additional revision shown in attachment 1 of your packet, and that reflects the recent Court of Appeals opinion that essentially indicated that a dwelling that was either destroyed or removed more than 5 years ago is not prohibited from being replaced. And so that is reflected in the draft before you. We understand that that case is going before the Oregon Supreme Court soon, and if to the extent that that's further interpreted by case law, the code before, the draft before you reflects the Oregon administrative rule language, and so if that's further interpreted, we could implement case law. At the September hearing, the board received public testimony regarding a variety of different issues. Staff have thoroughly reviewed those issues and responded to each of them in the board's memo. Today, we'd like to summarize staff's response and also revisions that are being proposed to address several of those concerns that were raised in public testimony. After the public hearing today, staff will recommend that the board close the public hearing and close the record and move a set a fourth reading for November 27th, and then also provide direction to staff to make revisions reflected in attachment 1, as well as a memo that's been distributed to the board today, which I'll discuss. We received testimony yesterday that was emailed to the commissioners and has also been, copies are available at the back of the room. Many of the issues addressed in that testimony have been addressed in staff's memorandum, and others that have not yet been fully addressed will provide explanation to in the staff report. So to address public comments, staff have made several revisions to the draft zoning sections. For example, there was in the currently adopted code sections for the F2 zone and the EFU zone, there's a provision that the planning director or an applicant can request a planning director determination of what use a proposal fits within. And we received testimony that that should be added back in. And so we've added that language back into the EFU and F2 zones, and with the clarification that an applicant can request a type 1 use be elevated to a type 2 planning director determination. In the objective citing standards, we added clarification that if soil ratings for agricultural soil classification and forest productivity do not correlate, then preference will be given to agricultural class in the EFU zone and forest productivity ratings in the F2 or F1 zone. We've removed a requirement to make findings to comprehensive plan policies for the template dwelling provision. The comments asserted that those should be addressed with zoning. We concur, and we made that revision. In the comments that were received yesterday, there was also some concerns raised about the language that remains that requires that a template dwelling comply with lane code and other provisions of law. We believe that that's not really an additional provision. That's just kind of a disclaimer to the applicant that there may be other requirements in lane code, such as floodway development permit or riparian regulations that an application still needs to demonstrate compliance with. So it's just kind of a disclaimer that there are other regulations in lane code and elsewhere and as a matter of law that need to be addressed. Concerns have been raised throughout the process that the amendments to citing criteria may preclude additional one-year timeline extensions, and that's because the requirements for additional one-year timeline extensions require that the criteria have not changed. And so, as discussed in the board's memo, this is a policy matter. It's something that the board could potentially address through adding an additional finding in the ordinance. And so in the memo that has been distributed to the board today, that includes an additional finding that if the board provides direction on, we could add into the ordinance. It essentially says that the amendments to citing criteria do not amount to a change of criteria for the purpose of additional one-year timeline extensions. So that the changes to citing criteria wouldn't preclude additional one-year timeline extensions. There were some concerns that were raised in public testimony regarding the new commercial activities in conjunction with the farm use criteria. These criteria or similar criteria were in the model code, and so we reviewed case law going back to the late 1970s, long-standing case law that appears to require these considerations. We ultimately added them into the draft because it provides some transparency as to the requirements in case law without requiring the applicant to go back through and do that case law review themselves. I will note that in the model code, they're listed as three options. The way we have it drafted, they are three requirements. So there's no or provision. You have to meet all three criteria. And we believe after reviewing case law that would be required, that there requires that holistic review of those requirements. There were some concerns raised about outdoor mass gathering provisions and the fact that our proposed outdoor mass gathering provisions do not include the or other gathering provision. That or other gathering provision comes out of ORS Chapter 197, and it's in the language that says what's not a land use decision. We've incorporated the outdoor mass gathering allowances from state law, and that's just an exclusion as to what's not a land use decision, but we believe the language that we're proposing wouldn't preclude someone's right to assemble that, meets the definition of what's not a land use decision or other gathering. So we believe that wouldn't be precluded. Concerns were raised about the non-high value farm dwelling criteria. Currently, Lane Code indicates that the income test is $32,500, and that comes out of a calculation from state law, which we understand may have, the calculation may have been done based on alleged Osu Soils Report. We have not been able to locate that soils report. It hasn't been entered into the record with public testimony. And because we haven't been able to verify its existence or what exactly, what data it provided, we recommend including the language that's verbatim out of state law and not codifying something that we haven't been able to verify at this time. I will note, though, that by including state law, it does still allow for that calculation to be provided in future applications. So an applicant could still make that argument. We don't believe it's more restrictive. They could still present that soil report, that calculation, if it is located in the future. There were concerns raised regarding type 2 citing criteria. We have included for not the clear and objective citing criteria, but the type 2 citing criteria, we've included the Oregon Administrative Rule language for the forest zones. Comments have asserted that these are discretionary. However, these are type 2 citing criteria, so by the nature of that application, that would be appropriate. As part of the code modernization project, we have aimed to, or endeavored to, align the code as closely as possible with state law. So part of the intent of including the OAR citing criteria was to do that, to include the language directly out of state law. We understand comments have raised that the current citing criteria was adopted in the early 90s, in 1991, to address the citing criteria in the OARs. The OAR actually includes a provision that allows local governments to implement certain standards that are more specific, that address certain considerations. And so what we've researched ordinance, that ordinance from 1991, and we have found that several of the findings, those assumptions and those findings haven't necessarily held true over a nearly 27-year period. And so we do recommend retaining the OAR language. I will also note that there is a provision in the OAR, or excuse me, we have made a further revision in the memo before you that essentially clarifies that an applicant we can still consider different considerations that the OAR spells out. So things like clustering near existing dwellings, location near existing roads. So some of the things that are taken into consideration today that come out of that OAR language, we've clarified that those can still be taken into consideration to meet the citing standards. And that's in the memo that's before you. Finally, and I'll just touch on this a bit and Keir will, and then I'll hand it over to Keir. But concerns were raised regarding the new standard recommended by staff that grading, clearing, or thinning of a site before an application cannot be used for justification of a building site. This provision is not intended to prohibit clearing, thinning, grading, or commercial forest practices or other uses prior to application. It's merely to clarify that those things alone cannot be used as justification to meet the citing standards. In part, the purpose of the OAR is to minimize wildfire risk and to conserve forest values. And so we believe that the OAR requires a more holistic review that is achieved by addressing the citing standards and in a manner that doesn't focus on pre-grading, thinning, and clearing. And so with that, I'll hand it over to Keir, and he'll further address this issue.
Sure. Thanks, Amber, and good afternoon, commissioners. So as Amber mentioned, I wanted to talk a little bit more about this big issue of changing the criteria to preclude the clearing of a site as a factor that can be evaluated and where to locate a dwelling. This was one that was raised in the testimony we received just last night. It was also brought up by the same individual in public comment back on September 11th. And I kind of want to frame the issue a little bit because this one's kind of nuanced and a little bit more complex than some of the other issues. What is being recommended is for two reasons, which Amber mentioned. First of all, the citing standards that are currently within our forest zones were implemented for two overarching reasons. The first is to minimize the impacts of dwellings on commercial forest operations. So where dwellings are located, to minimize those impacts that they may have with large-scale commercial forestry operations. The second is to protect lives, property, resources from wildfire. Those are the two overarching reasons we have these citing standards in the forest zone. So those fire citing standards, when somebody applies for a dwelling, the code requires that we evaluate a number of different factors. Where the dwelling's located in proximity to the road. This gets at how quickly first responders can get to the site. Is this structure located or clustered around other dwellings? It's more efficient for first responders to go to one small neighborhood as opposed to these disparate dwellings located far down dead-end roads. The steepness of the site, the soil capability, is the part of the property where the dwelling's proposed to be located. Is it the area that has soils which are poor for growing trees, or is it the really prime soils for growing trees? And it goes on. There's a number of different factors that we're supposed to evaluate in determining where a house should be sited. What we regularly see is that home sites are pre-selected before an application is even made, and that staff goes through that evaluation to determine which factors, what the balance of factors are. Home sites will be identified ahead of time, pre-cleared, and then an application will be submitted. And the basic argument, and it's a good argument, it makes sense. They say, you know, this home site's already been impacted. You know, we went and we cut out a pad for the home site, and we built a road to that home site, so it's already impacted. That's the most logical place for the home. Well, that circumvents the whole intent of the code. I'll give you just one quick example. This goes so far, and usually where these home sites are is they're on the highest part of the property with the best views, because that's what generates the most revenue for the developer. We just recently saw in the last couple of months a development proposal come in where evidence was submitted in the record by neighbors showing that this site and this specific home site was being marketed before an application was even made as a view lot, and that developer had gone so far as to develop infrastructure at the home site and put a well in. So what that tells me is that the developer, well, it tells me that the code isn't functioning because the developer feels confident enough to invest money in a home site and building a road and putting a well in to an area that he thinks is pretty much guaranteed to get his development in that location. And that circumvents the entire intent of this multiple series of factors that we're supposed to be evaluating. So as part of this, there was testimony brought up last time, and the specter of Measure 49 was raised, and that's the legislation which, if the county implements new changes in rules that could impact the value of a property, the county could potentially be liable. And county council's here and they can speak a little bit about that. But what I want to make clear is this proposed change isn't, we don't believe it's not going to impact anybody's ability to develop their parcel. And Commissioner Farr, you had some concerns you raised last time about the number of front doors. This will not reduce the number of front doors in the county. This will impact where those homes can be built on the property. So probably what it will impact is the price those lots are and the affordability of home sites. I've heard recently view lots close to town, which are being developed, are being marketed at $500,000 for bare land. These are view lots. These are, very nice lots. Well, this change might bring that value down slightly because you can't put it on the most prime part on the location, but it's not going to diminish your ability to place a home on that lot. So I just want to make that point clear.
Circumstance. Okay.
Yeah. Well, in any circumstance, because you're going to qualify for a home regardless. It's just where on the lot it can go. Probably what it will have an impact on is how safe that home site is from wildfire. That's the real change we're after here. So actually, this might be a good time if County Council wanted to weigh in on the Measure 49 issue at all.
Happy to answer any questions about it. Measure 49 stuff can be kind of thorny, but primarily in this case would come up if there was a reduction in the value of the property as a result of the regulation newly adopted with this residential use. It's hard to calculate. I mean, kind of tying in with what Keir was saying, it would be, I think, hard to calculate that difference in value if you're just talking about what location on the site this home was being located. I guess you'd take into account the view and reduction. The end of the day, it comes down to the board as to whether to, if a case is made successfully, it comes to the board to decide whether to pay compensation for the reduction in value or to waive the application of the provision. And that would be essentially a case-by-case evaluation by the board if that kind of case came up. So.
And I'll just reiterate that I think these particular instances with the changes that are being proposed, the chance of a successful Measure 49 claim seems few and far between. I mean, obviously a claim can always be made, but we're not rezoning land in such a way that prohibits development, and there is that option for just altering the location of the dwelling on the home site. Another piece around Measure 49 is that regulations intended to protect health, safety, and welfare, those are generally exempt from the provisions of Measure 49. So to the extent that some of these changes are being proposed to protect home sites from wildfire, that's a potential option within the code. So I did see a couple kind of question looks through some of the testimony that Amber was providing. One had to do with the other gatherings, and there are a few other things. So I know there are probably questions. I think now is probably a good time to turn it over to that, unless I think we're all finished. Yeah.
Well, actually, if I may add one thing, and I believe I skipped over this, so if I may just return to it, there was one other piece of testimony having to do with accessory farm dwelling provisions and whether you can have a relative live in an accessory farm help dwelling provision. And so, and that was raised again in the testimony we received yesterday. So we did a little more research, and it appears that language is in ORS 215-278, but it appears to have a more specific use than was proposed. It appears specific to a specific type of accessory farm help dwelling, and so we're suggesting just clarifying that provision is only for the purpose of 215-278. But that concludes our staff report. Again, we're recommending that the board move a fourth reading to November 27th, and we're happy to answer any questions.
Commissioner Farr.
No real serious question on other activities, but just could you name a couple of other activities that would fall into that category that are non-land use?
When we're talking about the other gatherings provision?
Other gatherings.
Okay, so that change is basically being made. The code currently had language that called out mass gatherings as an allowable use and then other gatherings. what we've found is that an other gathering isn't technically a land use under ORS 197015. So there is no need to mention it or regulate it within the code because it's your constitutional right to assemble. So there's no need to call it out specifically.
That's clear enough, thank you.
Commissioner Sorensen.
I'm interested in hearing more on the topic of the perspective that aspects of this proposed code will restrict development and the countervailing view that it protects the public in terms of fire danger and allows development on appropriate other areas of a particular property. I'd like to hear your discussion of that again.
Sure. I'll try to maybe make it a little more clear. But it gets down to this newest provision that was added by staff rather late in this whole process, and that seems to be one of the more contentious ones. And that came out of a couple of recent examples where we've seen this pattern of development occurring on properties where home sites are being located, where it may not be the most logical place from a fire protection standpoint. The code has us look at this number of different criteria and trying to determine where that home site should be located. And we've realized that that's routinely being kind of gamed or circumvented.
Well, in this hypothetical, do you want the house located near the road so emergency vehicles can get to the house? Or do you want the house not on the view point because you don't want people to have the viewpoint? What's your sort of rationale for wanting to control where it goes on the property?
I'll say it's a couple of things. It's not our rationale. This is currently an administrative rule, and these rules were written back in the early 90s. There was a work group by the Oregon Department of Forestry that actually put these together. So the intent really is around protecting the forest and the homes from wildfire, and vice versa, protecting the forest from homes that start, or from fires that start in the homes. So yeah, there's a number of factors. Being close to the road is one of them, but clustering around other homes is another. The steepness of the lot, the soil capability, that's a big one as well. The intrusion into forest lands, oftentimes these, especially in a lot of the development patterns, these long skinny lots that, butt up from the road where the prime forest land is higher up on the hill. And that, of course, is where they want to site the home sites, and it's closer to that larger F1 industrial forest land right behind them. So that's kind of the balancing act. Again, it's not an effort to roll back property rights, as has been put in the testimony. It's more about protecting the health, safety, and welfare and having the code operate the way it was intended to.
So I've got Commissioner Lykin, myself, and then Commissioner Farr in the queue right now. Commissioner Lykin.
Thank you, Mr. Chair. So, Kira, I want to talk a little bit more about that piece in particular. So you're talking about a group that was formed in 1991?
Well, it's not a group. It was the Oregon Department of Forestry when these rules were written.
Yeah. So I'm going to bring back my argument today, 1991, and what's going on today regarding fires. But not only that, it's regarding what the federal government has done as far as the ability to build out roads on federal forest lands. I mean, it's been really hit hard. So right now there's been road closures. You have an inability, especially when you look at some of the lands in Lane County, the ONC lands in particular. You have federal lands, you have the checkerboard, federal, private, federal, private, federal, private. And the challenge, I think, there, and so what you're hearing from private folks, especially in the forest lands, and I'm going to talk about, it's probably more the commercial forest lands. So what they're requesting is that we need actually to have an ability to build out more opportunities so people can be living there, stationed there, because of the fact that there are these growing forest fires that are happening and things that are being uncontrolled. So you look at a community like half of Redding was just basically lost. You had the wine country down in California. You had half of Napa Valley basically lost from a forest fire. They're without the fuel reduction. And so I guess my question would be, coming back to the, in particular on this, and this does come from Mr. Close's, and on 16.211.5A IIFF, the grading, clearing, or thinning of an area of vegetation for forestry or non-forestry uses prior to submittal of a land use application cannot be considered as justifying factors in determining the building site. My question would be why?
Well, I think for those kind of the reasons I just explained, that the code has within it provisions that are supposed to factor in the wildfire safety issue.
Wildfire, when you think of a group put together in 1991 to where we are in 2018, if you look at history of wildfires compared to then to where we are today, they have changed dramatically.
Exactly.
And so what you're hearing now from folks is that there's a significant issue, not just of harvesting, but there's a significant issue out there about talking about fuel reduction.
Right.
And so when you're talking about trying to, on a site and in an area like that, you want to have an ability to do some clearing out, to thin out, to have that ability. Otherwise, you don't know what's going to happen from there. And so that's I don't, to me, my feeling is right now it's very hard to justify basing something on a report that came out in 1991 to where we are today. All I'm going to ask is, and I'm not asking staff to do this, 'cause this is a lot of work. I can do it on my time, and what I've done is that you look at the historical on wildfires and how they have been presented. We've talked about this a lot from just on the federal government side. So the U.S. Forest Service doesn't do attack. They used to, by the way, at one time, many, many years ago, long time ago. ODF, with their contract with BLM, will. Well, we're fortunate that ONC lands are actually under contract by the BLM. So you're going to have that in place by the ODF. The concern I have is the properties owned by private individuals that are in that mix, that are close to that mix. And so you've got to talk about what can you do on the fuel reduction side.
I think I understand what you're saying. I think
Yes.
I misunderstood you at
Okay.
first. So you're absolutely right. And from 1991 to now, the fire regime has just gotten more intense. And it's all about fuels reduction. It's all about what you do in that defensible space around your home. So you're exactly right. This code would not preclude that. It would, if these changes were made, it would make the fact that the code is intended to site a home site in a less vulnerable area more of a reality. And then once that home is located in that area, the code requires those fuel breaks and defensible space around the structure. So the difference is somebody goes in and they cut a pad for a home up in the thickest part of the forest on top of the hill, and they want to put the home site there, or should the home site be somewhere in a better location? In either case, fuel breaks are the right thing to do around that structure.
Well, and I want to make sure that, because from my perspective, I think this had to be really clarified and put in so it's not so, right now what I read, it sounds kind of definitive, and I don't think you want to have definitive. I think you need to really look at this and say, it's a judgment issue is really what it is. It's like what's going on in the NFL right now. It's all judgment but really it's a judgment issue. And so, like for instance, in the Thurston Hills, BLM has some properties up in the Thurston Hills. They just issued a timber buy. It's been put together. I actually met with BLM probably 6 months ago and went over the whole aspect, what they're looking at because of the Willamette Lane property. Believe it or not, that property is not near as close to that Willamette Lane trail as what you would think people are suggesting. But my argument has been, wait a minute. So if you don't want BLM to go through and thin this out and clear this, in a sense, the brush out, and also do a little harvesting up there, so you want the Thurston Hills to turn into Redding, California. Great. I don't know about anybody else, but I don't. And so that's why I think this is so much of a judgment issue as well. And I think we have to be careful about making sure you don't put things based on a report that came from 1991. So I appreciate the clarification, from you, Kier, on this, and appreciate, I'm kind of going all around the place, but I think you've heard from this board on many occasions, this issue about the forest fire issue. It's significant, and the patterns have changed so dramatically here in the last 4 to 5 years on forest fires and what they're doing to basically neighborhoods, that we can't have it. So language in the codes is so strict, or the feeling is strict, that you can't have that ability to, on some of the citing standards, to make sure that.
I agree, and this, just to
Okay.
clarify, this language would not do that
All right, and
at all. I mean, the
you
code
stated
actually
that, and I
requires.
appreciated that,
yeah,
but-
requires a fuel break, so this would not do that. And this is part of the reason staff have recommended this change, is because of the wildfire regime we've been seeing in the county in the last several years, so.
All right, thank you.
Thanks. So I'm probably going to go the opposite direction from Commissioner Lycan a little bit. The 1991 group that looked at citing standards was done with, there were folks from ODF there, there were folks from the fire districts there were folks that were, involved. It was a large conglomeration that looked at the aspects not only of fire protection, but also the aspects of forestry and protecting the forest values. And were developed, and they were actually adopted into our code, these citing standards, basically at the behest of LCDC, if I'm accurate in that. If I'm not, disagree with me, we kind of got told we needed to adopt these in, and we did. So, and they've so far stood okay and working out. So now we're talking about changing something that was done, with this cooperation of professionals and at the direction of LCDC, basically. So as we choose to change that, we need to be very careful about what we're going to choose to change in those citing standards. What I heard you describe, Kier, and if I was going to make a Measure 49 claim, I would start off in court with a tape of that part of your meeting where you just described it wouldn't be a 49 claim. Because the first thing you described was developers have enough knowledge, apparently, of our system that they are confident they can pre-site a dwelling knowing they can get it approved under our current code. And under that current code, they're pretty sure they can develop, they can market a property as view property because they're pretty assured that they can use our current code to get the siting that would be considered a view siting. That there's that much confidence involved in what our current code is. And what you then went on to say was, in talking to Commissioner Farr about front doors and all that, wouldn't change front doors, but just might change the value. And you even put out $500,000 dropping to a $300,000 value. Well, right there's your Measure 49 claim. So you've described one, a system that already has developers pre-siting because they're so confident in our current criteria, and two, the change in criteria actually decreasing lot value. It is a perfect storm for Measure 49 claim. I don't know how more completely you yourself describe the 49 claim. If I was an attorney, I would go straight to that video. That would be what I played in court. I'd stop it right after you talked about the developer that pre-sited the view and say, see, developers are so confident they can pre-site. And then I would stop it after you describe the $500,000 versus $300,000 values and say, I rest my case, Judge. I want $200,000 from Lane County.
Well,
Yeah, that, to me, tell me that that's wrong. So for me, this issue of adding in language about pre-clearing and all that stuff, we had, apparently we had an agreement back in the early 90s that we had enough in our siting criteria that protected forest properties and all that. And yes, maybe some people are stretching that and we're not meeting those goals. But at this point, the water is under the bridge. The cows are out of the barn, however you want to say it. If we try and close that door now, we are opening ourselves up to 49 claims. And I don't see how we can do that. So for me, I don't see why we're messing with this citing criteria that's been in place for so long.
So, a couple of comments, if I can, for the board's benefit, maybe. Part of that 49 case you've laid out, it presumes that it's legal and legitimate to base the citing of the home on considerations other than the standards that the state law set out about where the safest location for the house is. If the reason it's where it is because they decided the great view was there, and then they cleared the site, I don't know. I haven't looked at the standards enough to know whether that's consistent with what state law provides. But even assuming it is, the other piece of the 49 claim I guess you'd have to disprove as the plaintiff's attorney is that the standards proposed don't get to health and safety aspects, which excludes the 49 claim. It's not a standard that, or they're not regulations that 49 applies to if it deals with health and safety standards. And so I think got to take a closer look at what the citing standards are to get to the point you got to in terms of the 49 claim. If that helps.
And I guess I'll just, again, just throw this out there, that this was just a trend that staff identified in this code process. It was put in late in the process. We don't have a dog in the fight other than we know that wildfire is a growing risk in the county, and it seemed like this was an issue that was coming up with more regularity, so we're bringing it to your attention. It's a policy direction for the call, and we're not trying to push this argument at all, just trying to provide you the information.
Well, I have my concerns about wildfire also, but I have to separate those concerns when I'm dealing with land use code sometimes. We supposedly dealt with that in our original citing standards. Now what we're talking about is amending those citing standards and whether or not those amendments, one, was at the original direction or policy neutral, and whether they're becoming more restrictive, and two, whether it might create a Measure 49 claim. Grading of a site during logging operations, setting up log decks and cutting in roads happens anyway, quite often, prior to a site being declared as F2 and being rezoned. So pre-clearing happens, and sometimes that pre-clearing and laying roads in may actually make a housing site present itself. Sometimes it's done on purpose in advance, sometimes it's not. But to eliminate that criteria at this point, the reason it was kind of, people were able to argue that was it was originally anticipated that during normal forestry operations there would be clearing, road building, and all that. Whether some of it's happening sort of on purpose now, that's something that I don't know we can regulate through a code change. And I'm really concerned that we're setting ourselves up for a lot of litigation, potential appeal of this code change up through the courts by having that one specific section on the grading, clearing, and thinning. It's kind of like, is it really broke enough to have that fix in there, and is that fix going to generate more litigation than what you're trying to fix? And I foresee this as opening a Pandora's box of 49 claims. If like I said, I would, your statements that a developer has been around the system long enough to clear a site and install a well, pretty assured that he was going to be able to achieve a template dwelling there, and then talking about the difference between a view lot and a non-view lot. Really, and that's, you would have to argue successfully that difference between the housing sites was purely a health and safety issue to try and get around the 49 issue. That's not a clear path either, because everybody throws their experts together about forest fire and safety zones and whether or not the roadways at a different grade at the other site, I just foresee us spending a lot of money on, as much money on legal costs as the $200,000 Measure 49 claim, just trying to defend ourselves. So thinking of this up front, that may be something I'll be asking for us maybe in our reading to pull from the code, but we'll get to that later. We've still got a public hearing to have yet, and we have Commissioner Farr in the queue.
Thanks for that detailed line of questioning. Mine's a little bit more simple than that, and it's just a bit of an explanation as to my continual call for front doors, and it really is kind of out of your wheelhouse. But Mr. Mokrajewski and Mr. Hurley, today we heard from a lot of people who don't have front doors, and I heard yesterday in a meeting from staff that if we were to provide beds only, not front doors for people in Lane County who need them, we need 3,000 more. So my interest is always going to be, and I'll always try to steer things toward, making as many dwelling units available inside of the 1973 regulations that were passed in Senate Bill 100 as we possibly can. Not making it harder to add houses and front doors, but to always find ways to make it easier to facilitate it. Sometimes it seems to me, and more to other people who talk to me, that we and other governments just make it harder inside of Oregon law within Oregon law to build houses and to add dwelling units. So it's not just a message for you, it's a message for everybody in general, and anybody who's making decisions that ultimately will determine whether or not a place is going to be built, that we need to err toward allowing houses to be built, not err toward being more restrictive, as long as we stay within the law. And to me, that's something that you don't need to hear that today, Keir. You don't, but you did anyway, because it's something that I always say and I always will say.
Mr. Sorensen.
I was wondering if any of you could give your view on whether the draft that's currently before us is going to violate Measure 49. Well, I heard some criticism that it would violate it, and your words would be used as evidence that the county intends on violating Measure 49. I'm just curious whether you think that's the case,
Well, I can't speak.
or if you're glad that it's the case. Whatever.
Yeah. More work for the lawyers, yeah.
Right.
No, I won't speak for staff. But I don't think that the staff would put forward code amendments that they thought would violate Measure 49. And I think, and that's the belief I hold as well. At the same time, it's a lot of changes. It's a big code, and Measure 49 is always ripe for litigation claims, and so I can't say for sure that wouldn't come up. But that wasn't the intent, clearly, or there isn't, that I'm aware of, any items that have been added, deleted from the code where staff has said, yeah, that'll probably draw off Measure 49 claim, but what the heck, we'll deal with it when he comes.
So the focus of the draft is to avoid that. Is that a fair statement?
I would say at least that we're cognizant of the law, and we don't want to present things for this board to adopt that are going to result in Measure 49 claims if we can avoid it.
Thanks.
I'd rather hear, hey, we found a way to add another house on your lot.
And maybe an item for the legislature rather than this board in certain cases.
So if there's any further questions for staff, if not, I would like to open the public hearing. If I can get back to my script, wherever I buried it under the other paper. So flipping back and forth. So I'll open the public hearing, and we'll take public testimony in regard to the changes in Chapter 16. And after that, I think we'll get some additional comments from staff, and I think we have a sign-up sheet. And we only have 3 people signed up, so we'll limit your comments to 2 minutes. No. Bill can hardly move his hands in 2 minutes. Bill, you're first up, followed by Tom, and then Mike.
Thank you. Commissioners, Bill Close, 375 West 4th Avenue, Suite 204 in Eugene. You're probably getting pretty tired of this. I can feel your pain. This is really getting beat to death. I've given you another letter which was maybe it's today's date, it was written yesterday. It's based on looking at the code, which we got Friday afternoon. That was the first time it was available to us. That wasn't much time to get into this. I want to start out by saying that for those of you that read my letter already, you get it that I've got some energy about this. On page 3 of 4 of my letter, 2/3 of the way down, I've got a single sentence paragraph that says blah, 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 and then I have in capital letters that says, insert rant here. See that, page 4, 2/3 of the way down? So you can tell I had some energy about it when I wrote this. Now, there's no rant that follows there. I spread the rant through the rest of the letter, and then I forgot to take the all caps out. We're kind of rushing because of the short coupling between the hearing and when the draft code was available. Given a choice, everybody's put a lot of energy into this. Staff's put a lot of energy into it. Stakeholders, you folks. The goal of reorganizing these code chapters was a great goal. Chapter 13 and 14, they're in good shape. Those are 100% efforts. This chapter's got problems. In my considered opinion, which isn't worth any more than anybody else's, I think if the choice is between making the changes to the code that the staff wants to make now, I mean these open issues here, that it going with the staff on the one hand versus not making any changes and sticking with the current Chapter 16, you should stick with the current Chapter 16. And I don't say that casually. I've thought about it. I've talked to people about it. That's my opinion. And the reason is there are very substantial changes to the code, policy changes, that are reflected in the draft that's in front of you right now, as in particular the issues that are still on the table being discussed, most of which are the subject of my letter. So that's a pretty big statement, but I'm going to stick with that. Now, at the get-go, this whole exercise was supposed to be policy neutral. It's not policy neutral. And I would challenge staff to take each one of these issues that's currently on the table and explain to you why it's policy neutral. And they can't do that. The second thing I'd say is that there's nothing about Chapter 16 that needs to be changed in order to come into compliance with state law. It's in pretty good shape. There was a reference by staff to making a change to match the Court of Appeals decision in King. That's the Court of Appeals decision that says it's okay to look back more than 5 years when a person's asking to replace a farm dwelling that was removed. That is, it could have been removed more than 5 years ago. That was our application. We got an approval on that from the county. County said, we agree with you. It's a poorly written statute, but you read it correctly. You can look back more than 5 years. That was the staff position, director's position, excuse me. That was the hearings official's position. We appealed to LUBA, and LUBA said, no, it's a badly written statute. It's a badly written implementing rule, and we read it differently. We lost that at LUBA. Somebody else took that case, went to the Court of Appeals, and pitched the very same theory, the county's theory, to the Court of Appeals, and won. So there you are. It means it's a badly written statute. That is now on appeal at the Supreme Court for reasons known to whoever, very few people probably. The Supreme Court took that case. You never know what they're going to take. So it's fine the staff say tweak the code, but it's not needed to tweak the code to come into compliance with the Court of Appeals decision, because the Court of Appeals ratified and affirmed the original decision of the county, which was based on the county code. So clean up fine, but it's not a decision, it's not a change that absolutely needs to be made. Too much on that. I had some general comments from my earlier letter, and I've just repeated those here. This letter looks a lot like my earlier letter because really not much was changed based on my earlier letter, so I just pitch it back to you. I made some general comments in my earlier letter, and so here I've repeated those, and then I have a comment on that indented. So you can read that. That's just sort of big picture stuff. Let me talk about a couple specifics. The biggest issue here is this, the standards for citing forest template dwellings. This is really frustrating and galling. There are several pieces of this. The first piece is that really punishing, dumb language that staff wants to add that says, and I got it there on page 3, little FF, the grading, clearing, or thinning of an area or vegetation for forestry or non-forestry uses prior to submittal of a land use application cannot be considered as justifying factors in determining the building site. What's the point? I mean, as a practical, well, staff like to see houses near roads. Fire protection, access, emergency, whatever. Maybe it's low land, it's not worth as much, and that's attractive to staff. I don't know. But what if somebody goes and harvests trees closest to the road? Suddenly you can't put the house there. You have to go cut trees somewhere else to put the house. It just doesn't make any sense. It's just punishing. As a practical matter, here's what happens. People who have a small chunk of forest land, and they know from the surrounding development they're going to be entitled to put a house on it, they stand back and they look at their land. They hire somebody like Mike Evans or Jim Mann, who somebody really knows dirt, to go look at their property and say, help me plan this. Where should I put the house? Where should I cut the trees? And they do what's called a residential thinning or a residential harvesting, where you go manage the whole site. You look at where the trees are. You look at the topography, which is views, which is value. You look at roads. You look at access. You look at everything, and you figure out, okay, I can justify putting the house over here on this good view site, and I need to take out trees here in these other places in order to generate revenue, generate timber, and maximize my house site value. And I can do that under the current county citing standards, which we know are compliance with state law. Now, what's wrong with that? That's the way people approach these issues. They've been doing it for decades here. It works great. So that addition of that language, that particular provision there, if you cut it, you can't put a house there. It's just punishing. This, when staff say they don't have a dog in the fight over what these standards are, that's not true, okay? We had an application several months ago where staff were they were reading the existing citing standards the way they want you to amend the code. They weren't reading the way they're written. And the director denied my client's forest template dwelling because the staff said they hadn't shown that this is the best location for the house. Best location doesn't appear in the citing standards. It's a balancing test. The question is, what sites are compatible with all the forestry uses and the other citing standards? There can be a number of compatible sites. There's only one best site, and only the staff knows where that best site is, balancing all the factors. So the director denied that application because my client hadn't shown that the house was proposed at the best site in terms of all these things that staff wanted to consider. So we had to appeal to the hearings official, knock down, drag out hearing. You've heard me talk about this case before. Staff put a tremendous amount of energy into defending its denial. My client put $10,000 into challenging it. And the hearings official agreed with us. He didn't make any law. What he said in his decision was, hey, staff, these rules are settled for 20 years. It's a balancing test. These folks have met the balancing test. I'm reversing your denial. And my client went out the door with his dwelling approval and said, what's happening in that department? To which we said, we've been asking that question too. So what's happening now is staff is asking to amend the code to let them do, case by case, what they did to my client illegally in the matter I just summarized for you. That's what's really happening here. Staff's going to apply these new standards to tell people they have to pick the best site, and staff's going to be in charge of what's the best site because the standards are so discretionary. That's the problem we're facing. The third point I want to make on the forest citing standards is this language that's on page 4 that they want to add. This is really nutty. The italic language there, indented 1/3 the way down page 4. They want to add this to the code as a citing criteria. I'm just going to read it to you. And you, as I'm reading this to you, ask yourself, what does this criteria mean? How would anybody apply it? Quote, citing criteria satisfying section AII may include setbacks from the adjoining properties, clustering near or among existing structures, citing close to existing public roads, or in the event the subject property does not have frontage on a public road, private road, citing on the most level portion of the property and on the portion of the parcel least suited for growing trees. That's a standard they want to add to the code? This language comes from the state rule. This is the language in the state rule that's directive to the county to go forth and adopt citing standards. And they want to take that language and put it in the code as a citing standard. We already have citing standards. The county has already done what this language says they're supposed to do. If you put this language in the code, what does it mean? How does anybody apply it? Maybe it just, the staff says, well, this allows us to consider all these factors and decide whether this is the best thing to do, the best place for the house. That language doesn't belong in the code. Attached to my letter, this was the subject of some discussion earlier. Attached to my letter is a 1991 ordinance that you all passed, or your predecessors passed. The Department of Land Conservation and Development directed the county to go adopt standards meeting state law for siting dwellings on forest land. And the county did that. The county did that in that 1991 ordinance right there. There it is. This is the ordinance that explains why the county has to do this and what they're doing. And not only that, I mean, everybody knows this, but I'm going to show you the piece of paper. Here is the LCDC order acknowledging the 1991 ordinance as adopting standards that are in compliance with state law. This is it. This is signed by Richard Benner. It's like having a signature of the Pope. I mean, he's director of DLCD at the time, and he started 1,000 Friends of Oregon. And here he is saying, you folks in Lane County have done a great job adopting forest siting standards. Nothing has changed since then. You did a great job in 1991, those of you who were here. The state blessed it, and now the county wants to, the county staff wants you to change all that. Turn it into a big stew pot. I'm going to give this to the staff so it goes in the record. So you have a perfectly good set of forest siting standards. You don't need to change it. Staff is not going to be able to tell you that there's any change in state law that requires you to change these siting standards. What I heard staff say after they said they don't have a dog in the fight, they said they think that the current siting standards don't really reflect or implement the intent of the state law. Well, they do implement the intent of state law because they're acknowledged as being in compliance with state law. They don't implement staff's notion about how these things should be cited. Houses shouldn't be on the tops of hills where people want views. They ought to be down in the gully. So that's kind of my rant on the changes to the forest dwelling siting standards. Other items in here are really secondary. Item 6 is kind of fun. It's another one in the dumb category. Who thinks this stuff up? Item 6 on the bottom of page 5, staff is taking out of the code the income requirement, $32,500 for a woodlot dwelling, and putting in $40,000. And that's going to make it awful hard for people to get those dwellings. Harder. And on page 6 there, the staff explanation is a summary of the staff explanation for why they're doing it. I'm just going to read that paragraph because I want to take care and not be too harsh here. I was a little bit careful the way I wrote it. Staff's explanation for why they want to make this change is remarkably thoughtless. They agree that the $32,500 figure came from an Osu Soil Report, but they can't locate the report, and no one has given it to them. So they're changing the number. That's a dumb reason. They admit the Osu Soil Report exists. The $32,500 number is acknowledged. They can just leave well enough alone. Instead, they are seizing the opportunity to make things more difficult for people. people who can't get a woodlot dwelling simply are going, because those are properties that are mix of forest and farm. If they can't get a woodlot dwelling simply, they're going to come back to you and ask to have their EFU zoned property plan changed and zone changed to forest, so they can come and get a forest template dwelling. So what does that mean? Changing the plan and zoning to forest is a 2 to 3 year trip through the county after you pay your $20,000 filing fee or whatever it is, something in that order of magnitude. Once they get the plan and zone changed to forest, then they can get a forest template dwelling and argue about the forest dwelling siting standards. So it's, I just don't get it. It doesn't make sense. It's not logical. And I've droned on too long. I'm sorry. Thank you for bearing me out. Let me go back to my first point. Choice between making the changes recommended by staff or making no changes at all to Chapter 16. Leave well enough alone. The whole chapter is in compliance with state law. Let's not mess it up. Thank you.
Thank you. Tom?
Good afternoon, Commissioners. Tom Lanphier. I won't cover all the things that Bill talked about. I would like to talk about the citing standards, though. The staff proposal is to take the rule provisions and put them right into the code, even though we've addressed those in 1991, as Bill has described. What you're doing is going from the specific to the more general. So the code provisions that you're putting in place are open to more interpretation. They're more general. Open yourself up to more appeals. It's harder for people to address in an individual application. The one change about the grading beforehand not being able to be used in that analysis only works if you leave the current standards in place. Because if you're going to the more general provisions, you have nothing left to balance with that restriction on grading the site. So it doesn't quite make sense to add either one or to go to the more general. I'd like to see it stay with the specific provisions. Now, there may be problems, and yet time has gone by since 1991, and it may make sense to revise these provisions, but not like this. If you want to form a group with OD, get the Department of Forestry, stakeholders in the timber companies, the environmentalists, you know, if you get a group of people together to look hard at these citing standards, great, maybe come up with some improvements. But to do it in this manner doesn't really serve anyone any good that I can tell. The $32,000 provision, that is not just for woodlot dwellings. That's for all non-high value farm dwellings. So you're raising the bar from $32,500 to $40,000 for anyone trying to get a farm dwelling on non-high value. $32,500 is based on a report and the census in 1992, it can't change. If you do that analysis today of the average farm size in Lane County, you're going to wind up with $32,500 because the data you're using is from 1992. It can't change. It was adopted, it's in the code, it's acknowledged. Why not leave it alone? I think that's about all I want about. I'll let you guys go on with your business. Thank you for the opportunity.
Thank you, Mike.
Chair, Commissioners, staff, my name is Mike Evans, planning consultant, address 475 Oakdale Avenue in Springfield. Well, I think you've heard enough about citing standards, so I'm not going to get into that too much. One point I'd like to make that on the grading, clearing, thinning issue is that if you look at the code language, it says it cannot be considered. And so my reading of that is that if you have a site, and unlike maybe I didn't understand correctly, but like staff said that, well, you can still make an argument. The language as it is, it looks to me like, you know, if you do some clearing, you just eliminate that site. And frankly, there's a lot of grading, clearing, brushing, and that sort of thing that's done out there. As a matter of fact, the way things are going right now and the proof that you have to make to citing a dwelling, you just about have to do some clearing just to see what the grades are, and prove what the grades are, and all that sort of thing. Concerning the, I don't think, I guess I'd go along with Bill that I'd prefer that no changes be made in Chapter 16. Maybe that isn't realistic at this point. And if not, then I agree with what both Bill and Thomas said. Do not adopt changes to the citing standards for the reasons that they've said. I think there's going to be a lot more appeals. It's going to be much more costly, guaranteed much more costly from the landowner side of things, the staff side of things, and certainly the property owner side of things. I agree with what Tom said, that if there's a reason to change the standards that were adopted in 1991, which went through a very comprehensive process, months, many people involved to develop those standards. And if there's a reason to change those standards, then let's make another effort of it. This is supposed to be policy neutral. That's not policy neutral. So make that another work project or something like that if there's a need to change that. I'm not that concerned about the fire issues. Certainly that's an issue, but frankly on a one-by-one basis, we have to, when we get a template dwelling, we have to get a hold of the local fire department, and the chief or some of the people go out there, and they have to write us a letter before the county will accept or deem the application complete, that there's adequate access or will be access to the home site, and the home site is something that can be served by that. It doesn't matter where it is on the property. If they don't like it, if it can't be served, then we have to move our home site to another location, and there is some negotiation that goes on there. But the fire safety issue, I think, is taken care of to a large extent under that process. The existing standards are a balancing act, as has been said before, and it's a compatibility with the concerns for fire and fire safety, and also impact on adjacent properties, not just industrial forest land, but it is a compatibility issue, and it's worked quite well to determine where home sites were with not too much difficulty. Every once in a while, you will have an issue that come up again, but you don't want to hold everybody to that standard because there's some taking the advantage potentially. I'm not very familiar with the case that Bill was talking about, but certainly staff wasn't happy about that. Now, my biggest issue, however, with the changing of the citing standards, and I mentioned this the last time, I'll just reiterate, is there's a concern with the, if standards are changed in the F2 zone in particular, that the one-year extensions won't be allowed. And I do appreciate the staff's effort to put in language, as Amber mentioned, under public comment number 1. They're proposing to introduce some language that would state basically that the amendments to citing standards won't affect the ability to get one-year extensions. I really appreciate the effort. I think it was a good idea to do that. That would help some, except that I'm concerned that that really isn't, that's a county standard, but it's really required by state law. And so it's subject to interpretation. Does the county have the ability to make that finding and say that we, although we're changing citing standards, that doesn't matter. We can still continue to issue the one-year extensions. Maybe, but they're pretty drastic changes in the citing standards, and so it may or may not hold up. And I would hate to see people lose their ability, as many people discussed at the last hearing, the provision for 1 year, to allow one-year extensions. One last item is I certainly support the clear and objective standards that have been introduced into the code. And if you can, I think it's a good thing for them to stay. And the program is, if you don't meet these clear and objective standards, so you pretty much get the permit handed to you, then you can move on to subsection 5A II. But I'm concerned about the language there. And it says that structures that do not comply can meet the type 2 go through the type 2 procedure. Is that right? Type 2 procedure. And you address then the citing standards that do exist. What I'm afraid may happen, I'd like to see just a little rewording there, because it may be interpreted to mean that you have to go through the clear and objective standards if you can. Because the language says that the structures do not comply with those standards, then you go to the step 2. So if you said that the applicant or property owner had the option of either somehow, that would clear that up. So I think that's all I have to say. Appreciate your time and all the effort that you're putting into it. Thank you.
Thanks, Mike. So that was everybody that signed up to speak to us on Chapter 16. Was there anyone else that wanted to address the board on the proposed Chapter 16 changes? See none, then I'll look to staff for response to public testimony.
Sure. Thank you, Chair Bozovich. I just have a few statements. The first, I want to address the comment that perhaps the code, all of the work that's been done so far might be better off to not make any changes at all. And I'll just got a few thoughts around that. One, I just want to point out that a use table comparing and contrasting the existing code to the proposed code was provided to the Planning Commission. They were in support of this proposal as it was, and they recommended that the board adopt the proposed code changes. There have been a couple of small adjustments to the code since the Planning Commission. Well, not small. One of the bigger ones is this citing standard provision, which was recently added. So I certainly understand the concern there. But the Planning Commission did have a chance to evaluate all this and provide a positive recommendation to the board. I think there are a number of really good things this code does that will make it, frankly, a lot more user-friendly to the public. The use table, there's a lot of great features built into this code that staff put a lot of effort in to make the code more clear and objective and usable to the public that would be lost if this were tabled at this point. We've heard this concern about the code not being policy neutral. In an effort of this size, when the county was essentially trying to implement the model code, there's so many changes to be made that there will be small policy changes throughout. One of those policy changes is the clear and objective standards, which is an effort to make it easier for folks to cite on their property. So that was an effort that was a policy change, but it was a good policy change. There are policy efforts or policy implications in this code, and we've never tried to say that there aren't. I guess I'm just saying that at this point, I think it takes a careful look. If there are problems with the citing standards, we certainly understand that. I'm kind of reading the tea leaves here about a number of the citing standards. Those could be surgically removed from this code without losing the bigger picture here. I think there's been a lot of work put in. A couple other comments. The one about the staff increasing the low-value farm dwelling provision from 32,000 to 40,000. Again, that's language that's in statute. Part of this effort was to make the code align with statute. That was one of the stated goals. By adding that language in, it's never been our intent to preclude somebody from making an application under the 32,000 standard, and that argument could still be made. If one of the big pieces that we are missing was mentioned in the testimony, is this report. If that report could be identified, that would be a clear argument for why those the income standards are set at the way they were. I want to clarify again about the case that Mr. Close has brought up a couple of times about the hearings official. I just want to clarify that that wasn't an instance where staff was trying to make up rules. The director denied that application based on the citing standards that the location of the dwelling that they had chosen. When we actually went to the hearings official, the applicant in the hearing modified the home site. So the home site was changed as a result of staff's recommendation. And that's why it was ultimately, our decision was overturned by the hearings official. Had the applicant worked with staff initially to identify the accurate home site, we wouldn't have had a denial in the first place. So I just want to clarify that as well. Do you have some comments?
If I may add just a couple of things. So the Of the testimony that was provided yesterday, we heard again today, page 4 has a recommendation on the citing criteria that come for the forest zones that comes out of the OAR. And I just want to highlight again that upon further review, we are recommending a slight revision to that standard to clarify, to word it as a standard rather than what appears to be direction to local jurisdictions. And so we have recommended another revision to clarify that standard today. As well, on page 6 of that piece of testimony, and that had to do with the $32,000 income test. I believe we've addressed that piece. So I just want to highlight that in the memo before you today, we are recommending revisions related to the accessory farm help dwelling language, the citing standards that come out of the OAR, and also that piece in the ordinance about the 1-year timeline extension.
So, questions or comments from the board? And any discussion about closing the hearing and further board actions at this time? There's no objection. We can close the hearing. We can talk about the record later. Any objection to closing the hearing at this time? I'm going to go ahead and close the hearing and then open it up to board discussion. So I guess I can start real quick just to try and see if I can walk through some of the things that are in today's staff memo that have some of the language changes, so I can make sure I understand a few things. It looks like, and I don't know if some of the folks testifying got copies of the staff memo with the blue and the red additions. Looking specifically at the one that you just mentioned, Amber, the 5A III changes to try and describe that more as not generalized, but more as a criteria that appears to look like it satisfies that comment. Is that, as I'm looking towards the back of the room, is there generalized agreement that revised language is okay? Guys, you had a chance to look at that. I'm not an attorney, so I'm having a little bit of difficulty looking at what was originally proposed and what's written up now in red and blue and saying, yeah, that's not a generalized, it still sounds very generalized to me. To satisfy the citing criteria at section 5A I through AI2, consideration may be given to setbacks from the joint, its consideration may be given to, and it has basically almost the same language about setbacks and clustering, citing close to public roads or private roads, if that's the case. Most level portion of the property and parcels, and part of the parcels that's least suited to growing trees. It almost seems it's not that far different from the prior language, and I'm just wondering, is that, is it it really, it still seems very generalized in some ways, and it seems like all the other criteria we have about citing already addresses that. So am I missing something in the process and the numbering and going back and forth, that there's a necessity to even have that III in there? I mean, that's what I'm trying to get my head around. Is III necessary because we have to make some reference to it? Because under the one the II right above it, it talks about they have the least impact on nearby adjoining forests. Citing ensures adverse impacts on forest operations will be minimized. Closest access to road corridors, risk to associated wildfire, and so it covers a lot of that already. Mm-hmm. So I'm just kind of trying to understand why we have that triple I in there at all, and why we're messing with the language with it rather than deleting it. So that's my first question.
Sure, and we were just conferring, and we believe, and we'll take a closer look at this, that this entire section could be deleted if that was the board's direction. And wouldn't have an impact, but we can, again, look at that.
I'm just concerned that
It's redundant.
confusing particularly in an appeals process or something like that, for somebody to say, well, I'm appealing based on you didn't meet this triple I portion of it. And the applicant will say, well, I meet double I. You know, which is it? Which has precedence? So, you know, if there's not a driving reason to have that in the code, if it kind of got pulled in with the model code, maybe it's best, rather than trying to fix the language, just to jettison the language. Just a thought on my part. So I think I'll kind of recommend maybe that we do that, unless you guys can find a driving need to keep that triple I portion in there. So that gets back to double I, double F, which is the grading, thinning, et cetera. And this is probably the most controversial piece of the new citing criteria written in there. Yeah, I don't have a logging background. You know, I'm an East Coaster. So what I've learned about logging, I've learned from going on multiple tours with companies that want to take me out and show me what they're doing, et cetera. Everybody from the folks at R&R King that are good friends of mine and good friends of land use now, as they get cited about the replacement dwellings, because that's their family farm. That was the example that was used, that went through, and the Court of Appeals upheld our interpretation of what, you know, we thought was the correct way to interpret that statute, which was except for means except for, you know. Or I can't remember the exact language, but just, it was one of those, okay. But every logging site I've been to, just about, they drive a road into the site, you know, cross the hills, et cetera, to reach one of the highest portions of the site to be logged, clear that area, make a cutout of the high side, fill the lower side to level it out, and pull the logs up to that landing, because that's, you know, with cable logging, modern cable logging, even the overhead, you know, long line reach that the Kings use, that's kind of just the way you do it. You set that site up at the top of the hill. So after a logging operation, what's left? A road to the top of the hill and a cleared out, leveled site where there was a log yarding operation, you know, quite often. So there's that big disturbed site. Of course, now it's at the top of the hill, which makes it view. And for somehow or another to write in a criteria that says, we have to ignore the fact that that was previously maybe a log site, and you know, it was before certain forest practice rules, so there was no restoration work. So there's an already cut-in road. There's a huge leveled-out area. It was a cut on the high sides, so now there's no longer really soils that could grow trees, because you're talking about cut and fill, and that makes an obvious home site. And to not be able to look at that because we throw in that double F makes no sense to me. So, you know, for me, let's delete, you know, I'd like to direct a delete double F out of there. And I think we'll resolve a lot of issues there. And that avoids the whole measured 49 arguments we heard about. So at least for what I'd like to see maybe in this reading is, as we read it, to delete those two particular portions of the proposed code change. Beyond that, when it gets to the farm income for dwellings, I'm kind of I'm still confused as to why we even messed with it. because it's another place where you're raising a standard and going from one income level to a higher, which means it's more difficult, which means there's potential for, and this one I really would like to see a fire and life safety argument outside of Measure 49, that exempts you from Measure 49 on that. We're just increasing the criteria, and it does seem somewhat arbitrary that, why 40, why not 45, why not 39.5, what's our justification for 40,000?
I think 40,000 is the figure that was in statute or administrative rule. So that's what, and part of this intent of this code was to make the code more aligned with statute, but it's absolutely a true statement that we have an adopted code acknowledged at 32,000, and the direction is to leave it there. That's easily done.
That may be my third and final maybe direction, is to leave that one where it is. And beyond that, I don't think I've got much more to add. Commissioner Sorensen.
Just on this latter point about the OSU Soil Report, did you ever locate this report, or did the people that are commenting, did they ever provide you with it, or what's the mystery here about this number?
No, we've not located it, and it has also not been provided in testimony.
Okay. And we have been, what's the practical impact of changing the number from 32.5 to 40,000? What is the practical impact of that?
It would make it more difficult for somebody to qualify for a dwelling on a piece of land that has low-value soils. They would have to show that they were generating $40,000 in gross annual income as opposed to $32,500.
40,000 or more.
Correct.
Well, and if I may add to that, there's this other, so it's an either or. You either prove up the $40,000 in gross annual income from sale of farm products, or gross annual income of at least the midpoint of the median income range of gross annual sales for farms in the county with gross annual sales of $10,000 or more, according to the 1992 Census of Agriculture. So sorry, that's a little bit long-winded. That's the statute or OAR provision. And so the difficulty would be that the applicant would need to go do that calculation.
And compute that.
Mm-hmm.
Yep. Okay, thank you.
Correct me if I'm wrong, but one of the reasons it got set at 32.5 was somewhere along the line, supposedly that was computed according to the 92 census, and that's why we set it at 32.5 for this county?
Presumably, yes. We just have not been able to locate that analysis.
We just can't find the record. Yeah. Which, how many times has land management moved since 1992? Yeah, sorry, I just have to say, and it was all paper records back then, nothing electronic, so I can understand not being able to maybe find the detail, but there was a reason why 32.5 was picked. And to try and raise that and then throw the onus back on applicants to go and do the research necessary to prove a 1992 number, I think is probably onerous. So if I would recommend the board maybe stick with the 32.5 and the other two changes I've discussed. Commissioner Farr was in the queue.
And I'm in agreement with that, but you were all nodding, all three of y'all, regarding the removing the pre-clearing language. That seemed to be a pretty amicable nod among y'all. Okay, just wanted to verify that that's what I saw. Thank you.
Commissioner Lykin.
Thank you, Mr. Chair. So I will agree with Chair Bozovich's recommendations, with obviously my biggest heartburn being FF and in the 16.211, and that's the grading and clearing. So I obviously had heartache on that. I'll also concede the 1991 report, at least for now, even though the best picture that year was Dances with Wolves. The New York Giants defeated the Buffalo Bills in the Wide Right Super Bowl. Minnesota actually won the World Series. And of course, the Bulls beat the Lakers, and Michael Jordan, now a billionaire and an owner of a team, was the MVP that year. So That's how long ago that was. I just wanted to make that point, and I was 29 years old and had dark hair. So other than that, it's all good. Thanks.
My first child was born.
And your phone bill had long-distance charges.
Yes, it did.
I'd just like to say I'm in agreement.
Okay, thank you. So any further,
In addition to those three changes, which we're hearing, there was the recommendation brought up by Mr. Evans regarding the statement making it clear that you could qualify for either the clear and objective citing standards or the type 2. And I think that was our intent, and that's certainly something that provides more flexibility. And if it's the board's direction, we could make that revision as well.
so I'm going to look to the staff here real quick before I start asking for motions. I know we're on the third reading, going to a fourth, but we're asking for a lot of changes on the fly. Would it be better for us to come back with a fourth cleaned up? We can close the public hearing today, come back with a fourth reading deliberations with the cleaned up, and then go to a fifth for approval. I'm just a little bit concerned about trying to read all these changes verbally to qualify as a reading.
I think it's at the, and I stood up because I think you looked like you were looking at me, but it's.
Because, I'm also trying to keep a mental calendar in my head of how many more other land use actions we have to try and cram in before the last meeting of December, hopefully. I want to finish this year.
We have a lot of things, right, coming up, and I think it really is at the pleasure of the board. I think we do have a pretty clear understanding of what the board has directed us. I mean, we've heard the testimony, we've heard the discussion, a lot of the changes that we've had, Amber has already put into the draft. So I think we can come back with a fourth reading with the intention that the board will have some time to look at the draft before you, and then if there's concerns, then we can push it to a fifth reading, but perhaps we can leave it as a fourth reading, and then the decision is whether or not you want to make deliberations you can make on the 27th.
I'm just looking to my vice chair, who usually makes my motions. Can you possibly make a motion on this clear enough that it qualifies as the third reading, or do you want to move the third reading and directing staff to come back in accordance with our direction and comments provided here with a revised draft for a fourth reading and expecting a fifth? I'm a little concerned that this is going to be really hard to describe in a motion.
I agree.
Because, we are, we're deleting language, which I know legal staff says we can do without another reading, but we're also adding some language back in, and, like the change from 32.5 to 40, clarifying the issue of the type 1, type 2. That's not a deletion. So I'm a little concerned about trying to verbally adjust this reading and not doing it in writing on a fourth, and then having a fifth, which I know is time, but I almost feel it's necessary. They have the calendars out, legal staff's putting their heads together. We'll have a recommendation in a moment.
The 11th of December.
So what else happened in 1991?
I got married.
Oh, my God.
My kids were playing a lot of kids' sports.
I've been married for 9 years.
You kids were playing a lot of kids' sport.
You were? Okay.
I was still living in the suburbs of Washington, D.C. And I think I was working, speaking of baseball and stuff, I was working on the Bowie Bay Sox Stadium at that point.
Oh, my gosh.
Which was the AA franchise for the Baltimore Orioles. They're moving one of their other.
So I think we've put all of our heads together, and we agree, so I think the board can recommend that we make the changes, come back for a fourth reading on the 27th, which will be a relatively quick discussion, perhaps, and then we'll come back for a fifth reading sometime in December. Do we have a date certain? December 11th, we'll come back with for the fifth reading and deliberations.
We don't need to mention the December 11th in this motion, just close the public hearing, approve the third reading, have staff come back with revisions for fourth reading on November 27th.
And if the board chooses to close the record as well, you should make a decision about the record.
Close the public hearing and the record, yeah.
Very good, thanks.
Close public hearing and the record. Move the third reading, have staff make recommended adjustments for the fourth reading on November 27th.
Ready? All right,
Commissioner Lykin.
Mr. Chair, I'd like to move the third reading, close the public hearing and the written record on ordinance number 1808, and bring the matter of the amending lane code. I'm not going to go through the entire piece as written. So recommendation, staff recommendation, bring it back to the board for a fourth reading, 1:30?
No,
Just any time?
Yeah.
Okay. And staff recommendation coming back for a fourth reading on November 27th, 2018.
Second.
So it's been moved by Commissioner Lykin, seconded by Commissioner Williams to approve the third reading on ordinance number 1808, amending Lane Code Chapter 16, and closing the public hearing and closing the record, and setting a fourth reading on November 27th on an amended, code amended in accordance with the discussions today. Discussion to the motion. Seeing and hearing none. All those in favor, please say aye.
Aye.
Any opposed? Motion passes unanimously. Thank you, and thank you, everyone, for watching Sausage Made.
Thank you.
Okay, now we need to jump back to this morning. And let me see what I think we need to jump back to county administration announcements.
Oh, just a quick one.
Sure.
I don't know if you noticed this, today was election day.
Yeah.
And if you haven't turned your ballot in, you have approximately 4 hours and 50 minutes to do so. And you can do that at one of our 20 Dropbox locations. So 8 p.m. is when ballots need to be left at one of our 20 Dropbox locations. As of yesterday, we received 129,395 ballots. Voter turnout at 49.57%. That's almost 50% turnout as of yesterday. 2018, this year's returns are up approximately 23,000 ballots received when compared to the same time for the 2014 general election. Yesterday, we received 547 phone calls and issued 192 replacement ballots. In addition to our 5.5 full-time staff in elections and 2 borrowed staff from deeds and records, we are staffed with approximately 150 temporary extra help workers to assist us on election day. Our driver teams will be collecting ballots from those 20 Dropbox locations throughout today and until 8 p.m. tonight. Election results are posted at 8 p.m. on our website and then updated at approximately 10 p.m. and midnight and when our staff goes home for the night. And then the election will be certified no later than Monday, November 26, 2018. That's it.
Great. Any questions on that? If not, we'll move on to item 7B, which was Order 1811-0606 in the matter of approving a contract for design services related to the replacement of the Lane County Public Service Building and Harris Hall roofing system. Mr. Rickoff.
Chair Bosevich, Commissioners, that is correct. This is a motion to approve a contract that will really focuses on the comprehensive design and construction administration for a new roof on the public service building. The roof is currently 6 years beyond its lifespan. If you've had a chance to talk to our talented facilities staff. They will use words like crunchy when they talk about the membrane surface. That's not a word you want to hear associated with your roof. The real story is with the upgrades in equipment, there have been a number of additional perforations in the current membrane. It really is past its life. What this is a competitive process for qualifications. We had 3 bidders. We chose to go with WJE. They are the individuals who actually did the engineering design on the plaza level that finally stopped the leaks we experienced after the art display had perforated that particular membrane. So we've had a good track record with them. They through the qualification process, we did get a very reasonable bid. The only anomaly in this is we're looking at expending what we think to be 11% of the overall project costs on the engineering, and that is really due to the fact that the market is still very, very active and competitive bids are all coming in a little bit higher. So we're looking at expending $163,500 to get this work done, and we're hoping to get this done as soon as we possibly can. Hopefully we'll not have any more light fixtures fall from Harris Hall in the process.
You missed it, Gary. That's where it hit, right there.
Have to mark.
So any questions for Mr. Rickoff? If not, I will entertain a motion. Commissioner Lycan.
Mr. Chair, so like to move approval of Order 1811-0606 in the matter of approving a contract for design services related to replacement of the Lane County Public Service Building and Harris Hall roofing system.
Second.
Been moved by Commissioner Lycan, seconded by Commissioner Williams to approve Order 1811-0606. Discussion to the motion. Seeing and hearing none, all those in favor, please say aye.
Aye.
Any opposed? The motion passes unanimously. So with that, we're finished county administration. Move on to commissioner's business, and we have item 8A, which is Order 1811-0608 in the matter of designating a voting delegate to the Board of Directors election position number 5 at the Council of Forest Trust Land Counties. And that's actually for me to discuss, but basically it is as one of the Forest Trust Land Counties, we have a vote in the election of the actual council, and there's a position opening up, and we have to designate somebody to exercise our vote in that election, which will be taking place, I believe, coming up here shortly. So it's time sensitive, and you know, they had asked if I would step up and be that voting delegate. So that's basically the background behind it. If you have any questions, Commissioner Sorensen.
Has there been anybody recently, maybe you or Commissioner Stewart, has anybody recently tried to figure out where those lands are in Lane County? Are they all in western Lane County, or are they sprinkled around the county?
I believe a majority of them are in western Lane County.
Yeah.
And particularly, they're fairly close to Mapleton.
Mapleton. Yeah, that's my recollection, but I didn't know if there was any like East Lane component to.
Kind of west of Nelson Mountain Road.
Yeah.
And that triangle between Nelson Mountain 36 and 136.
Yeah. Thank you so much.
Any other questions? If not, I will entertain a motion. Commissioner Lycan.
Thank you, Mr. Chair. I'd like to move approval of Order 1811-0608 in the matter of designating a voting delegate for the Board of Directors election position 5 at the Council of Forest Trust Land Counties. And we've identified our chair, Bozovich.
Second.
It's been moved and seconded to approve Order 1811-0608. Moved by Commissioner Lycan, seconded by Commissioner Williams. Any discussion to the motion? Seeing and hearing none, all those in favor, please say aye.
Aye.
Any opposed? Motion passes unanimously, which moves us on to announcements from commissioners. I just want to,
Just real,
go ahead.
yeah, thank you, Mr. Chair. So real quickly, because we were down, well, I was out of country last week. I didn't get to share this, but the week before it was kind of interesting. So I got a text message from Susan Cox on Sunday night, and she was basically hosting. He's retired now. Of course, Pat was able to meet him as well. He's retired now, former UN ambassador from Korea, and he was also served as ambassador to the Kingdom of Jordan. So he was in town, and he was just, I think, spent about 3 days, 2 or 3 days here in town. And anyway, she all of a sudden had these meetings scheduled for Monday. She texted me and she said, I don't want to leave him alone. As an ambassador, he really enjoys playing golf. Do you mind taking him out to play golf? I thought, let me think about that. Yes. So it was interesting. Eugene Country Club had a tournament that day. Shadow Hills was packed until 4 o'clock. So I called my friends out in Emerald Valley. It was fairly wide open. And so the ambassador and myself, just the two of us, went out and played golf at Emerald Valley. And then the following morning, there was a breakfast between the sector strategy folks and well, myself included. But it was pretty interesting. His English, by the way, is very good. I was really impressed. And yes, ambassadors do like to play golf because he has a pretty nice golf swing. But I think what was really intriguing, though, was, as Susan put it, and it's pretty obvious talking to him, he's extremely well connected in the country of Korea. He's retired now, but he's still consulting with the foreign ministry of the South Korean government. And he was quite interested in, especially meeting with the sector strategy folks and talking about our ag products, wine, and other things. And then that evening, the Lane Community College Harvest Dinner was going on. He attended that, and I was able to introduce him to some friends that I have known over the years. They're very private, so I'll keep their name private, but they're, we'll just put it, they privately own the world's largest blueberry nursery, and it's located, headquartered here in Lane County. And they also have nurseries and farms in different parts around the world as well that they own. But anyway, he and the owners had a very good conversation about blueberries. And in fact, the owners just told me that he just now has a licensing agreement with the South Korean government to start shipping blueberries to South Korea on a consistent basis. So it was really interesting having that dialogue, the trade dialogue, and it really, you know, the Korean government is, from a GDP, is one of the top 15 economies in the world. We hear a lot about, you know, opening trade with China, which I'm not against, and I think we should, because they're now the number 2 world's largest economy. But I think what's really interesting about the Korean government, let's not forget, they're our friends and allies, and so it's really, to me, it was a good ongoing conversation that we can have here in Lane County in Oregon, and having a person like that who, while he has retired from his official positions, he has direct access to the administration, the leadership of the Korean government. And we have that ability right here in Lane County, especially through Susan Cox and Holt International, to have that direct line as well. And Susan is an honorary consul of the South Korean government as well, and she lives right here. And but it was really interesting, again, to have conversation with him and to really discuss about what are some of the products here, not just in Oregon but in Lane County. And our ag products are such a huge potential that can be included in the trade that'll go on between the state of Oregon and as well as in the Korean government. And so I just wanted to share that. It was really exciting to, not just to play golf, of course, with the retired ambassador, but also just to really have that conversation, overall conversation about what can happen in the future for Lane County in particular, but also Oregon and the connection with the Korean government. Thank you, Mr. Chair.
Commissioner Farr.
Thank you. Just very briefly, and perhaps you're going to mention this also, Mr. Chair. On Friday of this week is the changing of command ceremony for Veterans Legacy, which is they'll be actually officially changing commands, and I believe documents will be signed at that time. Public, I believe, is invited. It's a long way out there by design, but also by necessity. And we're all pretty excited about that. This Board of Commissioners has done a good job in changing the ownership of the Alma property, formerly a liability and now a great asset, not just to Lane County, but to veterans who are going to be utilizing the facility for rehabilitation and healing for many years to come. So, Ms. Mokarsky, thank you for your part in that. Ms. Rickoff, thank you for your part in that. And looking forward to the ceremony this coming Friday out at Camp Alma, starting at, I believe is at noon, Mr. Chair. So, thank you.
Thank you. Any other announcements from commissioners? Then I'll ask for agenda team request or work session requests. Seeing none, then we'll move on to review of assignments. Mark Heisky.
Just the two additional readings. The second reading scheduled for November 24th at 10:30 p.m.
PM or AM?
Did I say p.m.? 10:30 a.m. Let's do 10:30 a.m.
Let's get the lead out around here.
Yeah, let's get, second reading, November 27th, 10:30 a.m., thank you, regarding the ordinance on the curfew for the downtown county properties. And then the fourth reading for November 27th on Chapter 16. Chapter 16, we don't have a time certain as of yet, but we'll see if we need it. Probably 1:30. I imagine we'll do that at 1:30 p.m., not a.m.
Yeah.
10:30 a.m., 1:30 p.m.
Thank you. Any other assignments that we missed? Any other business for the board today?
Just when Commissioner Sorsen get the lid out, I almost broke out into a whole lot of love, but that's beside the
Seeing we have no other business, we are adjourned.
Getting a little pickled brain.